Welcome to #FUBAR with Vincent McCrudden, discussing important topics on critical areas of U.S. financial regulation and criminal justice. His guests include experts and scholars in those areas, as well as litigants engaged in the arena of legal battle. Let's strap in.
Okay, hello. Welcome to #FUBAR. I am your host, Vincent McCrudden. This is my very first podcast. And so in light of that, we are going to be discussing a portion of a very important right to every American, the First Amendment and the right to freedom of speech. My favorite quote is from Coretta Scott King. She stated, "Freedom is never really won. You earn it and win it in every generation." Each day in the United States, there are tens of millions of citizens who use some form of social media. They post, they blog, they comment on articles, or what others post or blog about. Each time they do that, they are transmitting it via interstate commerce, which is governed by federal law, and in many instances, state law. Equally, every single day in the United States, whether in state or federal court, there are people trying to dilute your constitutional rights for various reasons. There are courageous people and organizations who stand up to these people who try to dilute your rights. Some are known, many are not. Many attorneys and organizations know my first guest, but every person who uses the internet or U.S. mail has benefited from his stance. I would like to welcome Anthony Douglas Elonis as my very first guest. Welcome, Anthony.
Thank you. Thank you for having me, Vincent.
It's my pleasure.
Just to correct you, it's Elonis.
Elonis. Sorry.
Yeah.
I've seen people say it both ways, so I wasn't sure. I should have asked you before.
Yeah. I believe Roberts got it right at oral argument and then got it wrong when he announced the decision. I think that's, if memory serves, that's
as long as the result of the decision was right. That's what really counts, right?
Yeah, exactly.
Yeah.
I am also really honored to introduce my next guest. She was president of one of the most important organizations in the country, the American Civil Liberties Union, for many years. She is currently a professor of law at New York Law School and is widely considered to be one of the most influential attorneys in the country. She is also an author of many books, including her latest, published in 2018, Hate: Why We Should Resist It with Free Speech, Not Censorship. She is a scholar and an expert on constitutional law and civil liberties. I am honored and pleased to welcome my next guest, Professor Nadine Strossen. Welcome, Nadine.
I'm so happy to be here, Vincent, and really honored to share the platform with Anthony, because it's much easier to be a lawyer standing up for free speech rights, especially when you have a whole organization behind you. But to be an individual who is facing the full force of the United States government, standing up for your rights and doing so in a way that benefits everybody else, as Anthony did. He and people like him are my true First Amendment heroes and heroines.
Well, it's very nice of you to say, and we really appreciate you being on the show and sharing your perspective with us. And in the many cases that I've read on we're going to be talking in free speech, and we're actually a little bit later we'll be speaking on your real main expertise, hate speech, and with the recent post by Mark Zuckerberg on Facebook. On Facebook's effort to start some type of censorship on anti-Semitic language. We'll talk about that in a minute. But Anthony's case is so important because I think when I've talked to him, in a lot of the cases you read, they are some type of spur of the moment reactions to certain things. But Anthony is a really clever, really, really intelligent guy who is not your average person who understood the background of the First Amendment and specifically true threat speech. And so I think that's why Anthony's case is so important and why his perspective and his experience matter so much. So in that regard, this is an important topic, and we're going to start getting underway. Anthony, 2020 represents one of the most stressful times in American history with COVID-19 and people being quarantined. People have lost their jobs. Doctors and nurses are stressed to the max, both professionally and personally. Families have lost loved ones. There is evidence of elevated domestic and child abuse. All people respond to stress differently and have different methods of coping. A decade ago, you faced your own enormous stresses, but in your case, the way you cope with it was unique, and it went sideways in a hurry, and you found yourself charged with a federal crime. Can you explain to the audience a little of what happened back then?
Yes and no. It's hard unless you were going through it at that point in time, in my life. But just the initial pain of losing my family, not finding any support at work. I got sent home for crying, but I always had a smile on my face, and I was in a call center. So people didn't see my face, so they couldn't tell through the phone that I was crying. But, for me, it would have been nice if I would have had, I didn't want to be sent home to the apartment that my family was no longer present in. It helped to be around people. So I just as an initial, just reach out to people in your life and talk to them. But in terms of, my method of coping, off the record, when I was in fifth grade, I won a PEAT award for academic achievement, signed by Bill Clinton. So writing was in my background. I don't know why the FBI and the DOJ didn't really understand any of the context of the case. So
the stuff that I've read and stuff, Anthony, was you were let go from your position at your job. Your wife had decided to separate, and you had two young children. So these are the types of stresses that we're kind of talking about that millions of people can understand. And I think the thing is that how we decide to cope with it, and yours was through writing. Anthony, you've got something huge on your hat. Take your hat off.
Yeah, that's the spotted lanternfly.
Oh yeah, okay, okay.
From China.
Okay. Oh wow. Okay.
They're really bad around here.
Oh, wow. Okay.
You might see like 100 during this.
Oh really?
Program.
Oh okay. All right. As long as they're not going to attack you or do anything.
No,
to you.
Okay. They're not going to.
Okay.
They will not injure me.
All right. So the idea, Anthony, that not only were you obviously, and I didn't know that you were an outstanding writer, and that was how you cope with all the stress that was going on around you, which millions of people can certainly understand. But that you actually had, I'm not sure if you had aspirations, but you were certainly really interested as a lyricist, and somebody who really, really appreciated, I think, good writing in lyrics. I'm not sure from the musicality or from the writing standpoint, but can you tell people a little bit about that as well?
It was the music that helped me cope with the situation. Just some fact. The fact pattern was that when I met my wife. She had Eminem posters on the wall. She had a bunny rabbit named Marshall. We got married on Eminem's 30th birthday. This was in our background. This is another part of the context that the government failed to know. Would have been important to make the true threat determination.
I know this is difficult, Anthony.
Because we're going into this open wounds that I've had. But it helped me cope with the situation, at trial, my ex-wife said that I never listened to rap music.
Yeah.
I mean, that's not true at all. So I was up against impossible odds. I had multiple friends that would have testified at my trial, but when the United States of America, when you are asked to help someone that's going against the United States of America, no one wants to help. No one wants to know him. So, is
that what? Because I read, Anthony, that you actually were very social. And the stuff that I read, the stuff that you shared with me, you had tremendous amount of friends and a divergence of friends who were not only supportive but had given you advice. And I guess the place that you were at the time, you were kind of like, no, I understand this. I understand what I'm doing. I appreciate it, but I gotta follow this road. So I think that we both know, and Nadine probably really understands sometimes, that in all the stuff that you've written over the years, when it comes to being charged by the federal government, they typically will take things not only out of context, but they'll portray you in the worst light that they possibly can. They're not there to really tell the story of you or others. At that point, the point that they cross the line is typically to get a conviction the best way that they know how. Do you concur with that?
I would. Yeah, that's my experience.
Right.
That's my experience. And going to the context, that's one of the factors in determining whether speech is a true threat. And, whose context? My context? The government's context? Because my context is totally different than the government's. And is it just the free for all? And like, I lost my job. Like, that's part, like, do we determine that, like, everyone that lost their job, like, we got to watch your speech? I don't understand. And the standard hasn't been set by the Supreme Court. You got Watts, which was per curiam. Virginia v. Black is, that didn't shake out the best way.
Can I interject something, please, Anthony?
Absolutely.
You're so knowledgeable about the law. You've learned so much. I think most listeners and viewers are not going to be aware of a very important concept you mentioned, which is true threat, right? That's the term that the Supreme Court uses to distinguish a punishable threat from the kind of way we use the word threat in everyday speech, right? Oh, I hear students on college campuses say, I feel threatened by the fact that Donald Trump is holding a rally in my state, or I feel threatened by the fact that there's going to be Antifa demonstration. That's not enough for the speech to be punished. But in the really important case you mentioned, Virginia versus Black, the Supreme Court said to be punishable, the speaker has to mean to instill a reasonable fear on the part of the person or persons to whom the speech is targeted. And by the way, it does have to be targeted to a specific audience. It can't just be a general statement like a song lyric or a rap lyric or a political speech. And that person or small group of persons to whom the speech is targeted has to feel a reasonable fear that they are going to be subject to harm. In other words, it's an objective standard, not a subjective standard. So if you have a thin-skinned person who happens subjectively to feel fear, that's not enough. And in Virginia versus Black, the court said that even burning a cross, which conveyed by the Ku Klux Klan, which conveys a threatening message in the general sense, cannot be punished as a true threat unless the people burning the cross were doing so at a specific audience and meant to instill a reasonable fear on their part. So I think the law was very much in your favor at the outset. And why did the government choose nonetheless to prosecute you? That's another question.
Well, I think that Nadine, that they came to warn Anthony. I think they were aware of at that point, once they had gotten hold of the total context of what he was writing about. I think that they came to warn him. Anthony can interject if I'm wrong. And then when he reacted on social media, and this happens a lot in cases that I see, is actually some type of either conflict or interaction with the courts or with the police that somebody responds to. Is that when that's when the law enforcement elevates it and they decide to prosecute. And I think that's what happened in Anthony's case. Am I wrong, Anthony? That I think within days after the FBI coming, that was really the final nail. Pretty quickly, they were going to prosecute you after that.
Yeah, I mean that's the timeline. I wish I had it in front of me, but it was sometime in November, right. Mid to late November when they knocked on my door, and then December 8th was when they arrested me.
Okay, so Nadine, going back to so what we're going to try to do here is we're going to try to talk to young millennials if we can, and explain to them through Anthony what they can or cannot say, where the line is, if we possibly can. And so specifically, what Anthony was charged with was Title 18, U.S. Code 875C. And that is primarily, and this is the language of it, whoever transmits in interstate or foreign commerce any communication containing any threat to kidnap any person or any threat to injure the person of another shall be fined under this title or in prison not more than 5 years or both. Now, as you had mentioned before Anthony's case, once Anthony wrote what he wrote, it became strictly an objective standard. And the standard was that it's not how Anthony intended it. It was how an objective, reasonable person could interpret it. And that was the standard at the time. And I wanted you to the government's burden was that, number one, the defendant sent a message in interstate commerce, check. Number two, a reasonable person would view the message as a threat, check. And then up until Anthony's case or post Anthony's case, the defendant intended the message as a threat. And that's the key really ingredient here. Can you opine a little bit or share with us, Nadine, where is the line and where should people stay away from it as far as true threats? So
both elements are required. The speaker has to intend to convey a threat that has the impact of putting a reasonable person in fear of harm. Both elements are required. And as I say, I think the Supreme Court had made that clear in a prior case that that's required as a matter of freedom of speech. Because if we simply allowed somebody to be punished as a criminal subject to incarceration because of negligently saying something, not intending to instill a fear, but, having that impact nonetheless, just think of the burden of self-censorship that all of us would exercise, because who wants to run the risk, that somebody might actually feel fear even if you didn't intend it. And this is actually a basic principle of all criminal law. The fancy legal term for it, which I know both of you know, is mens rea. You have to have a guilty intent. You have to have a specific purpose to cause the harm. We are not going to subject you to deprivation of your liberty, incarceration, even to the horrible burden of prosecution even if you ultimately are acquitted and exonerated, as Anthony ultimately was. But what a terrible ordeal to have to suffer just for saying something that some people interpret in a certain way. And there are so many examples of really important speech in art, in politics, that use threatening language in the general sense, loose sense that we use that has not been held to be punishable as true threats. One really famous example, and there are famous examples that involve racial justice. And I think this is really important because we have such ferment in this country now, appropriately, about police abuse of power. And again, most police officers are courageous and wonderful people, but then there are some who engage in abuse. We sadly know that. And there one case involved the NAACP arguing against racial discrimination, arguing against police abuse, and using language that sounded very threatening. So one leader of the NAACP, who was leading a boycott against merchants who were white merchants who were discriminating on the basis of race, said, if anybody breaks this boycott, we're going to break your damn necks. And guess what? The Supreme Court said that was protected free speech, because when you're engaging in politicking and exhorting and campaigning, for racial and social justice, you can't channel your words nicely and politely. There was a lot of controversy. This case didn't get to the Supreme Court, but lower courts that I thought of when I read about Anthony's case. I think it was in the 1990s. Ice-T or Ice Cube? Forgive me. I'm really ignorant about rap. But there was a song called Cop Killers. Remember that? Mm-hmm. And a lot of people were trying to censor that because it literally was advocating killing of police officers out of the rage and fury about the fact that police officers were killing mostly, black men who were innocent, but because of racial discrimination. And fortunately, the lower courts that heard those cases said that's protected free speech. It's artistic, it's political, it's conveying really important messages. Let me give you one other example. It goes back to the 60s, but so reminiscent of issues that we have now. An African-American man who was protesting against police brutality, against the Vietnam War also. He was at a meeting with other young black men in Washington, D.C. who were protesting on these issues. And he was afraid he was going to be drafted. And he said, if they ever draft me, I'm not going to kill my black brothers in Vietnam. The first man I'm going to get in my sights is LBJ, referring to Lyndon Baines Johnson, the President of the United States. And he was prosecuted, and that case went all the way to the Supreme Court, and the Supreme Court overturned the conviction. They said,
I think that's the Watts case, right, Anthony? Yeah, that's the Watts case. That's
Watts.
Yeah.
So you basically can't look at the words themselves. You have to look at the overall context. And an incredibly important aspect of the context is, what is the intent of the speaker? Is the speaker trying to convey an artistic message, political protest, vent his rage and his sorrow and his heartbreak, as Anthony has described he has done?
So I want to go over something very important, Nadine. So here's going back to Anthony's case for 1 second. Anthony, correct me if I'm wrong. The Supreme Court didn't rule on Anthony's language, so it wasn't truly dedicated to First Amendment. What they did was they looked at the statute and they said, is general intent enough, or do we need to, like you just explained, do I really need to have criminal intent? Can the court? Does that have to be the burden of the court and the jury to say? One of the things about Anthony's case is that, and I don't think it came up until later on, but Anthony's wife did have an order of some type of protection in. But it wasn't it wasn't clear to me that it was based off of the things that he wrote. And I haven't read anything that she knew definitively what Anthony was writing directly. He wasn't writing directly to her. And so one of the things that I know from the Second Circuit is that the Second Circuit now holds true that there should be some type of recipient reaction. Now, when you were saying, Nadine, earlier, I want to bring up a case that I was just kind of brushing through this year, because there's a couple thousand cases that the federal government charges every year, at least prosecutes every year. I'm not sure how many diversion agreements there are out there where they will bring a case and then offer a diversion agreement, give somebody time to attend anger management or something else, deferred from prosecution. But there's at least a couple thousand cases that are prosecuted on this statute at the very least. There's also a sister statute, 876C, which is the same type of thing, sending threats via the U.S. mail. But anyway, I came across this case, and it's interesting on a number of different reasons. So there's a man who I'm not sure, you guys can judge for yourself. Former U.S. Attorney General Holder, I'm going to kill you. My name is blank. Former U.S. Attorney General Eric Holder, I am going to murder you. My name is blank blank. We had spoken in February 2010. I was a United States unconstitutional convicted a prisoner by common pleas court of Cayuga County of Ohio by Judge John Sutula through the second part of the clause of the double jeopardy law of the United States Constitution, stating that a man cannot be put twice to jeopardy of loss and liberty. I mean, a man cannot be put in jeopardy of loss of limb for the same. I mean, a man cannot be twice in jeopardy for a loss of limb for the same charges. I'm sorry, I started. We had spoken. My name is blank blank. If you get this message, it's kind of rambling. My first impression reading it is that, and I'll ask you both your impression, in that where's the protections? This man either is under the influence of something, it seems like. It's not really that coherent. The directs, I'm going to murder you, I'm going to kill you, are direct threats. As far as recipient reaction was concerned, as they do in the Second Circuit, there's no evidence, I didn't read anything, that former U.S. Attorney Eric Holder actually read it. It was actually placed in a voicemail, and it was transcribed through Microsoft software. So I'm going to ask you both, in just kind of this one instance, when somebody is so definitive, I don't think you could state it more clearly. He names the person. He says, I'm going to murder, I'm going to kill you. It seems pretty immediate. What's your feelings on the prosecution of this one particular man? Anthony, you go first.
I mean, you hit all the points in terms of, it named the person, which from my initial learning, I read United States versus Baker, which became Alcabaz in the Sixth Circuit, because he was using a pseudonym on Usenet. And in that case, he named the student that he wrote the story about. But you're right that the fact that Eric Holder was named does go against him, and he was pretty explicit about, it wasn't like, for instance, one of mine was fold up your PFA, put it in your pocket. Is it thick enough to stop a bullet? It would be a rhetorical question versus what he said, which was pretty much like, I'm going to kill you. So it would be harder. But then, like you said, it was rambling, and if we're going into intent, not at minimum, I don't think recklessness can ever suffice. But so if we're dealing with knowledge, did he have knowledge? And I guess the government would argue just by saying I'm going to kill you, you would have knowledge that someone would take that as a threat. But I'm not the government, so. But I think you're right in terms of it being closer or at minimum at the line.
I completely agree. I think that at a minimum, the government would have to take this very seriously and investigate it. I have been the target of similar threats, and I've been very glad to have the government investigate it. But look at the big differences between that case and Anthony's case. First of all, it's not artistic expression. Secondly, it doesn't have all of the disclaimers. I don't think we've mentioned that. Anthony's writing was constantly having disclaimers that I don't mean this literally. This is, and so it's much more similar to what the Supreme Court called hyperbole in the Watts case, right? Nobody's taking this literally. There was no indication in the example you gave, Vincent, that it was hyperbolic rather than to be taken literally.
Right, exactly. And so what is your feelings on let's just say that the government took it very seriously and rushed to prosecute him. Should there be some intermediary process to judge whether he's of mental capacity, or was he maybe under the influence? Is that a defense, or should be another process to protect obviously government officials or ex-government officials, or is just kind of prosecuting somebody in an objective standard? He said it. We could prove he sent it. He ended up going to trial stating that he denied he sent it, but I'm sure that they had other evidence that he did. But what's your feeling of those types of cases where people may be under the influence or mentally unstable? What's the role of the government in those cases?
The prosecutor has an enormous amount of discretion. The fact that somebody that you think that you could win a criminal case successfully prosecuted should not be enough of a justification to actually do that, especially when we have such broad agreement across the political spectrum that we have relied on over-criminalization of too many kinds of antisocial conduct that could be better dealt with in other ways through dealing with the mental health problems, through dealing with the substance abuse problems, through using a restorative justice approach. And I think many people have recognized that incarcerating somebody is not the most effective way to make them a more constructive, productive member of society, but to the contrary. So I personally think that criminal prosecution should be reserved as a last resort when other measures of constructively intervening to help the person and to prevent that person from doing any actual harm. We should exhaust all other measures to do that before we lock them up. Right.
Anthony, going back to the Supreme Court case and getting it there, we could tell the audience, right? It's very, very, very low percentage to get a case to the Supreme Court, to be granted a petition of certiorari. So you get it to the Supreme Court. They add an element to it, and they basically state that no, there needs to be mens rea in the statute. You had written, which was incredible. I'm not sure if that's true or not, but I saw in some of your writings that you were aware that the Supreme Court had not reviewed a true threat case in like 25 or 35 years. I mean, you knew that in your writings, which was incredible to see. So Alito and Thomas dissent. Nadine Alito basically says that, which was weird. He says that artistically, and the government said that Anthony wasn't an artist, and so they brought up, I guess, Eminem and other artists, basically stating these things in an auditorium with thousands of people in an artistic thing. But I think Anthony or his defense team or Anthony himself said, well, what about Eminem when he was Marshall Mathers in his basement writing the lyrics, and nobody knows this guy from anything. So I think Alito's response or dissent wasn't wasn't great. But so Anthony goes back to the Third Circuit, and they call it a harmless error. So Anthony, as far as I knew, you are actually not exonerated. You went to prison for 4 years. Anyway, are you a convicted felon now? Are you exonerated? What are you?
I am a convicted felon. Yeah, so I got 44 months. I did 3.5 years. And you're right about the harmless error. It went back, and the Third Circuit determined that no reasonable jury could have found anything other than the fact that they would have found me guilty. Is basically what the Third Circuit said. All
right. So Nadine, I'd like you to comment on the law on that. The Supreme Court remands back the case, stating that the jury was given erroneous directions, basically erroneous instructions, and the Third Circuit said, "Well, never mind. Under harmless error, we found the guy guilty. We find the guy guilty anyway, and we're going to make the determination that a reasonable jury wouldn't have made a different." So, can you comment on that process or harmless error or?
I think that is a shocking abuse of judicial power, not only violating the liberty, the free speech rights, and depriving Anthony of physical liberty in the most literal sense, incarceration, as people now say, putting him in a cage, but also depriving the jury of the prerogative and Anthony of his right to a jury trial, which has been incredibly important throughout the history of this country, and one of the major rights that was protected even in the original Constitution, that we so cherish the judgment of our peers as opposed to federal judges, and some of my friends are federal judges, but they have essentially lifetime appointments. They are not accountable to we the people the way a jury of our peers is. And I certainly consider myself a reasonable person, and I did not interpret Anthony's language as a true threat, a punishable true threat. And by definition, the Supreme Court itself did not, right? If the court thought that there was only one way to interpret that language, what would have been the point of remanding it to the Third Circuit?
Yeah, well,
but as you said, very few cases get to the Supreme Court. So, an unharmless error will still go unremedied if it's not one of the very few that make it back to the Supreme Court.
Well, I think it's my experience as well that you had said earlier that I think Congress had mandated the Department of Justice in general that prison should be a last resort, and we could go into that. I'm sure all three of us go into that, another few hours. But I think here is an indication that you get to the highest court in the land, and Anthony is a convicted felon today for a few things he wrote on paper, and it will affect his life for the rest of his life, regardless. He's more famous than most people because his case is quite well known in the legal circles. And one of the reasons I wanted to bring him on is to get people to get to know him, see how bright he is, see how educated he is, and during a lapse of judgment, but really strategic judgment. He was very aware of a lot of things, but he wanted to just cope and just kind of vent this way. And it ended up being a life changer for him, as it is for thousands of people every year. As we are in an election year, one of the things that I also want to ask you both is that outside of a personal struggle and stress that Anthony has, that millions have, I don't engage that much, but on social media, Twitter, articles that are written, Facebook. It gets really heated. What is the line of kind of ethics and morals and just kind of being good citizens to one another? Where is the line of language we can use to one another? Because I can see where, as I explained earlier, there are a lot of times where people get engaged. I saw one case where a man was pulled over by just a local policeman. They noticed some pot in his car. He turned the pot over. They gave him a citation. He went on his way. And then him and his buddies pulled over like a half hour later, and they put something on YouTube or social media with the citation, burning it, and says the next time the cop comes around, he's going to shoot him in the head. And so he's sitting in jail presently for something not well thought out, but it was under the standards chargeable. The police got wind of it, and they charged him, and he was prosecuted successfully. So we're here today to try to really reach millennials or anybody, and especially in election year. What can we say to one another? How do we talk to one another on social media without going or being fear of going over the line and being prosecuted? Either we're talking to one another and threaten one another, or we threaten a government official like a candidate like Joe Biden or an incumbent president like President Trump. Nadine, you want to go first?
I would say that when you are talking about a police officer, and some Supreme Court justices have argued, and I agree, that they should be people who are especially have especially thick skin for very vituperative criticism, right? Because a lot of people in the heat of the moment when they're being arrested or questioned, especially if they feel that it is unjust or unwarranted, are likely to mouth off against police officers. And officers, of course, they should not be subject to a true threat where the person literally intends to frighten them, much less should they be subject to actual violence being carried out. But when somebody is just letting off steam and expressing anger and frustration about discrimination and abuse of power, police officers should learn to be resilient and not have to constantly arrest somebody for or add a charge of resisting arrest, which is what often happens. If you're talking about a political candidate, I think that, we have to take that very seriously. But again, with making sure it is not political hyperbole. It's not just rhetoric. I saw a lot of statements online when Donald Trump got COVID. I hope he dies. I wish he would die. And by the way, there was some pressure on social media to take off that kind of speech. One of the points we haven't yet talked about, Anthony and Vincent, is that even if speech is protected by the First Amendment, social media can go beyond the First Amendment and restrict whatever it wants to restrict under its so-called community standards. So they could say, we don't want any violent rhetoric at all, even if it doesn't meet the true threat standard. And not only do they not have to respect our First Amendment rights, which only protect us against the government, but as being in the business of communications, they have their own First Amendment rights, which include the right to kick anybody off their platform or to kick any expression off their platform. So people, of course, have to be aware of terms of service, content moderation standards. Now, all of that said, I'm going to say something that I said in my book, and I feel very fervently. Just because you have the right to say something doesn't mean that it is right to do so. I think we should engage in self-restraint. I think we should engage in civility as long as we can convey our feelings and our thoughts in a restrained manner than we should. Anthony was engaging in artistic expression. He had very strong emotions at the time. I don't think it would have been hard for him to find other ways to convey that expression. But if you want to convey a strong disagreement about a public policy issue or about a political candidate, you can find a way to do that, certainly without sounding threatening or without sounding insulting.
That's a great point, Nadine. Nadine, I was going to ask you about that before. We had talked about that briefly last week, I believe, the idea that people should know that private companies maintain the rights and their own standards of what's going to be on there. And I think that they're starting to do both Twitter and Facebook, probably Instagram, are going to start doing that more and more. There's a lot of pressure to do that, and that's going to come from Congress, or has already started in Senate hearings, putting pressure on them with the possibility that they are monopolies if they don't start to control their content. So it's going to be a huge issue going forward to people. But thank you so much for your thoughts on that, because that is something very, very important. Anthony, your answer to, I'm not sure how active you are on social media anymore, what you see, but what's your advice to people who are, sharing thoughts or engaging in political hyperbole or discourse online?
I guess my advice would be careful, because I don't even know where the line is. I boil down the argument is that the Constitution exists because of the character of speech, such as what we're talking about. If you look at, Thomas Paine, we could talk about incitement, how he incited the revolution through his speech. It's very, very, very difficult. I am upset that the Supreme Court hasn't set the standard. I know there's constitutional avoidance, but at some point it becomes dereliction. I mean, look at what we're dealing with. I don't know how to solve it. I'm not, that takes a lot of thought. And like you said, that's what they're currently doing, as we speak. What you were referring to, I believe, was Section 230 with the immunity for the social media company.
Right.
Yeah. So, I wouldn't know how to solve it. I would just, like I said, be careful, because I as educated as, I have made myself, on the law, or at least the First Amendment, I don't know where the line is for true threats. I don't know where the line is for incitement. That's going to be decided in each individual case. And again, then when you say that, you get into the chilling effect, breathing space. If people don't know where the line is, then there's a lot of speech that people aren't engaging in that might be beneficial. But it is important for people to be kind to each other. I was very abusive to my, even if we say what I said is protected by the First Amendment, it was still very abusive. And I understand that, and I have a lot of guilt for the moral aspect of it.
I appreciate your thoughts, and I'm sure Nadine does as well. Anthony, you're a brilliant young man. I think you can add a lot of value to society. We all make mistakes. Whether you view it as a mistake, you seem like you view as some of it as mistake, regrets some of the things you've written, people that you've hurt. It doesn't seem like the man that you are at all, the man that I've come to know in the past month or so, and what I've read. And so I encourage you to continue to fight. I pray for you and your family, and you heal, and you can add value to society. Anthony, as far as your case, and I think you've just answered the question, and it's been my reading and understanding, and as well, is that they had an opportunity to maybe look more specifically at First Amendment or the language. And I think the circuits are still the whole idea of the Supreme Court is to really kind to conform so that everybody in the country is aware of the law and what the consequences are. And I think from the cases I'm reading, it continues to be, even with the element of burden in your case, there seems to be ad hoc prosecutions throughout the country. It seems you're nodding your head. You agree with that?
Yeah, there's different standards. There's just a law review article that went over the different standards that have come up after in the 5 years since the case was decided. So yeah, they bypassed the First Amendment and decided on mens rea and different standards still throughout the circuit. So, and you had Kansas versus I'm going to mispronounce it, Boicher, was denied cert, but Thomas filed the dissenting a dissent to the denial of cert, and then in Florida v. Perez, Sotomayor filed her dissent to the denial. So it's eventually they're gonna take a true threats case again. It's just a matter of time.
But even when there is an agreed upon constitutional standard, so in something, in another example that you mentioned, Anthony, intentional incitement of imminent violence, where it is likely that the violence will occur imminently, the Supreme Court unanimously adopted that very strict speech protective standard unanimously in 1969 in an ACLU case involving members of the Ku Klux Klan. The court said even advocacy of violent or lawless conduct cannot be punished. It can only be punished if the speaker intends to incite imminent violence, and the violence is likely to happen imminently. So a very strict speech protective standard, but as with the true threat standard, it's a general standard. You have to apply it in every case based on all the facts and circumstances, the full context of that case. And so even if you agree on the standard, reasonable people, judges, jurors can disagree about whether the facts of a particular case satisfy that standard. Let me give you one very pertinent example. Donald Trump was accused of intentionally inciting imminent violence against a protester at one of his rallies when he was running for president the first time around. And remember, he said things like to his supporters, go get him out of here, get him out of here. And he said other things such as, I'll pay your lawyers' fees, and, we used to carry them out. And, there was enough there that a reasonable jury could find that satisfied the intentional incitement standard, right? Because the Supreme, just as, the exact words are not determinative, because it can be a dog whistle, right? You can clearly communicate the idea, even if you don't say, go beat them up, right? And so there was enough for it to go to a court. And ultimately the court said, it's very close, but we're going to emphasize the fact, we're putting a lot of weight on the fact that in addition to all of that inciting language, Trump also said, don't hurt them. And I also think that one of the factors there was this is political speech, and so the court's going to err in favor of too much protection rather than too little protection, because we want to avoid self-censorship in these really important expressions in the context of a campaign.
So there's a case that I'm aware of back in 2010 where somebody in Sarah Palin's campaign had put a crosshair,
yes,
like gun crosshair, on the district of Kathy Giffords, and within a few months, terribly, she was obviously shot, and so you had talked about, and very clearly too, it's not just saying things over the voice. It's not saying things online, but it's also symbolism that is not, that could be interpreted maybe as true threat. I'm not sure. Nadine,
or as an incitement, right?
Or incitement. So yeah, they kind of cross over it sometimes, right? Anthony brought that up before. So it's as a matter of law, as far as symbolism, I'm not on Instagram. Maybe you guys know better than me, but it's primarily through pictures, right? So you could actually instill fear or make kind of threats through symbolism, right?
There was a famous case in which I think it was the lower court said, in making the point that you don't have to use express words to convey a threat, they said, they cited a scene from The Godfather where somebody wakes up and there's a severed horse head in bed next to him. That's conveying a threat, perhaps even more powerfully than words could do, right?
Right. Well, I want to thank you both so much for taking the time on this really, really important topic. I'm hoping it reaches, a lot of people so that people will understand a little bit better. And you're both, tremendously informative. Is there anything, Anthony, you'd like to say before we finish up?
No, I would just like to thank you for the opportunity today, and thank you, Professor, for participating.
Anthony, you would get an A+ in my First Amendment course. I'm really dazzled by your detailed knowledge.
Yeah, encourage him.
Sorry you had to learn it the hard way.
Well, somebody once told me they always shoot the first guy through the door. So I think we can all agree that Anthony was the first guy through the door, or one of the first guys. But hopefully we can learn from Anthony's case. Nadine, thank you so much for your scholarship. And for steering Anthony and I in the discussion, being cornerstone for it. We really, really appreciate your participation. And, reach out to Anthony and encourage him. I think he can be somebody very, very important on this topic going forward,
Anthony, you can write a law review article as well as rap lyrics.
Thank you very much.
And good luck on your podcast, Vincent. So honored to be on the very first one.
Yay, first one. Thank you so much, guys. I'm honored to have you on as well. Have a good day. Thank you so much.
You too.
All right, bye-bye.
Bye.